that decision, and you will find his reasoning at page 160 to 161 with reference to that case of Michael Ngaduda versus County Assembly of Tana River, and he goes on to say that you round off. And it is our argument, Mr. Speaker, sir, that when you are rounding off, you can never round off to fall below the line. You can never round off to fall to less than 1/3. And if you are to do that, then you would be acting in contravention of the law. Mr. Speaker, sir, with that said, I would pray now to play that video and request, Mr. Speaker, sir, for 5 minutes for my colleague, Mr. Tonen, just to finalize on that issue, on the preliminary objection. Kindly, Mr. Speaker, sir. For my colleague, Mr. Tonen, just to finalize on that issue, on the preliminary objection. Kindly, Mr. Speaker, sir.
Before we proceed to count the votes, I have a very important message to communicate. Honorable members, please note that a person shall not be elected as Speaker of the County Assembly unless supported by votes of 2/3 of all the members of the County Assembly. 2/3 for us, 47. We need to have 32 votes plus, 32 plus. Now, the candidate who in that ballot receives the highest number of votes and the candidate who in the ballot receives the next highest, in case we don't get the 32, those are the only candidates that we shall go to round 2. Now, when we go to round 2, if they tie, we shall go to round 3. Unless that tie is broken, is when we shall declare the Speaker. Thank you. Now I will ask the Sergeant at Arms, please open that thing.
I think that's okay,
Our
Mr.
control
Speaker,
sheet is the number of votes first. The one to count first, 47. If they are
Mr. Speaker, sir, that shows the election of the Speaker, who made the arguments that I've just referred to, in which he says, because it's at 1.3, you scale it down, you round it off to the next.
Council for Governor, we've heard the video.
Yes, thank you, Mr. Speaker, sir. Mr. Speaker, sir, then in closing, it is my submission, Mr. Speaker, sir, that there are 2 issues, both yourself and this Honorable Senate need to address. The first issue is what is the meaning of at least in the Section 33 of County Government Act? What is the meaning? And when you apply the calculation in respect to KERICHO, does it mean 31.3 and above, or it can be scaled down to 31? So the first issue is what is the meaning of at least in Article 33 of the County Government Act, as read together with Standing Order number 74 of KERICHO County Assembly Standing Orders. Number 2, the second question, Mr. Speaker, sir, is the question of how do you treat a fraction where it relates to human beings? Are you going to say because it's 0.3, you dismiss it and scale it down to 31, or even 0.3 itself represents a person? And this is very significant, Mr. Speaker, sir. When you look at the situation of these proceedings, being, Mr. Speaker, sir, that there were 47 MCAs in KERICHO. 16 said we are not attending, number 1. Number 2, they said we do not support the motion. The other than 31 were present and they supported the motion. Mr. Speaker, sir, following the tradition of both the Senate and the National Assembly, it is always the case that when members have not voted in favor of, it is deemed that that vote was not in favor of. And so the 16 must be treated as having opposed the motion. It cannot be given conjecture that the 0.3 could exist in the 16, Mr. Speaker, sir. It is my argument, therefore, then, Mr. Speaker, sir, that clearly it didn't meet the threshold. And, Mr. Speaker, sir, I wish to say that considering the precedent from your colleague from the National Assembly, we pray that for purposes of consistency, Mr. Speaker, sir, unless you have a very strong reason to disagree with him, you adopt the reasoning he has applied for consistency and clarity of law. And secondly, Mr. Speaker, sir, that if the criteria is used differently from Nyamira, from National Assembly, from the election of the Speaker, from the impeachment of Honorable Chepkoin, then it would amount to discrimination. Mr. Speaker, sir, I had requested for just a little that it said 5 minutes. Could you allow him just 2 minutes, Mr. Speaker, sir, kindly?
Council, your time is up. Your time is up because you kept repeating yourself. Same arguments in different form. So you may want to rest your PO there. Maybe I need to ask you.
Yes, Mr. Speaker, sir.
In response to the preliminary objection raised by, not really an objection, but a matter, a preliminary matter from the County Assembly, you have no problem the affidavit dated the 13th of October 2024 be admitted and be part of the record?
I confirm, Mr. Speaker, sir, that I have no objection, and we have discussed both of us, and subject to the Senate and you, Mr. Speaker, sir, we were agreed that they accept our replacement documents properly paginated, and we will have no objection to the
the application for, as far as the witness is concerned?
We strongly object, Mr. Speaker, sir, but as I said, we have this restraint of the order, and we want to be very measured not to seem to be violating the order that we already have in our favor.
Council for the County Assembly, you may now proceed to respond to the PO as raised by the Council for the Governor.
Thank you, Mr. Speaker, sir, honorable senators, for the opportunity. The two preliminary objections are opposed by the County Assembly. To that effect, Mr. Speaker, sir, we will be asking you to allow a copy of the replying affidavit to be supplied to senators, because we will be making reference to the same. It is already with the Secretariat and marked as volume 8. If that can happen, Mr. Speaker, sir, with your permission, I could proceed. The two preliminary objections.
Do you have that? Where is it contained?
It is yet to be supplied, but it is with the Secretariat pending your ruling, Mr. Speaker, sir. So we can have that done.
Which affidavit are you referring to, Council?
Volume 8 of the Governor's, of the County Assembly's documents, volume 8.
Are you referring to the affidavit of 13th of October 2024?
Yes, indeed, Mr. Speaker, sir.
Is it contained in any of the volumes, or it's a standalone?
It's a standalone volume titled Volume 8.
So can the Volume 8 be made
Volume
available
8.
to honorable senators?
Yes.
It's a standalone volume, Volume 8.
I can confirm it is with the Secretariat, Mr.
Very well.
Speaker, sir.
Just
But I could proceed because I will not be making reference.
You may proceed.
Thank you. Mr.
Proceed, Council.
We object to the two POs on the ground that the very nature of a PO, Mr. Speaker, sir, and honorable senators, is that it has to be on a pure question of law. What Council for the Governor is inviting you to do at this juncture is to consider matters that are disputed, matters of fact. It is settled law that if an issue is contested, if an issue is in dispute, that can only be determined by way of evidence. When you look at the issue of existence or non-existence of the court orders, the County Assembly has strongly opposed that line of argument and has brought evidence to show that there were not court orders. In fact, the County Assembly is arguing that those court orders are either forged or a manipulation of the judiciary system. That evidence can only be tested if we bring a witness before you to be able to clarify on that issue. That cannot be done by just submissions from the bar. On the issue of whether the motion met the threshold, the 2/3 rule, again, Mr. Speaker, sir, you will note that this is an issue that has been contested. We will be producing evidence before you to indicate indeed that that threshold was met. How then, honorable senators, are you able to make a determination without listening to the evidence, without looking at the materials that both parties are relying on? We submit that the only way to do that is to allow this matter to proceed on merit. Then you can question the validity of a certain fact by cross-examination, by examination in chief, and by questioning the witnesses that will be relying, or rather seeking to produce those particular evidences. I note that Council has sought to rely on Rule 14 and 30 of your rules here to make an assertion that the decision on the 2 POs lies with the Speaker. We beg to differ, Mr. Speaker, sir, on the following reasons. One is that today the Senate sits not as a legislative house, but a quasi-judicial body. So any decision to be made must be made in your capacity as a quasi-judicial body. So the question then is, who is sitting to hear the matter of impeachment of the governor? Is it the Speaker or is it an individual senator? My submission is that it is the House that is seeking to listen and give a determination on the question of the impeachment of a governor. And judicial authority is usually aimed at settling a dispute between 2 parties. There are 2 ways of making that determination. One is on a technicality or on a preliminary basis. 2 is through hearing on the merits of the case and making a determination. Either way, that decision can only come from the fact finder, from the judge, from the jury. So the invitation that the Speaker sitting in his capacity as a Speaker can make this determination means that the decision of impeaching the governor or not impeaching a governor shall have been made by the Speaker alone, who does not have the legal mandate to listen individually to an issue pertaining impeachment of a governor. On that basis, then, I invite my learned friend, Mr. Njenga, to take you through the merits of the 2 objections. Thank you, Mr. Speaker, sir.
Mr. Speaker, honorable members, I'll go straight to the objections because of time. In addition to the argument made by my learned friend, I invite the Honorable House, August House, to consider the import and purport of Rule 2 of the 3rd Schedule of the Standing Orders, which grants express jurisdiction to the Senate on 2 things: A, to investigate the matter, and 2, to make determination on the particulars of the allegations. It is our submission that the power to make the determination, even on issues of law, remains always with the Senate, and it cannot be derogated by the application or by the interpretation of Rule 30. Rule 30 is clear. It's only on admission, competence, and any other issue regarding evidence, but not the competence of the entire motion. I proceed to respond on the question of the court orders that have been referred to by counsel. In making this response, I refer entirely to volume 8, that is the reply in affidavit of the County Assembly. I'll urge 3 quick points on that because of time, so that I can allow my colleague to refer to the last limb of the PO. First, we refer you to paragraph 8 to 13 of that reply in affidavit that speaks to the validity of the orders. The County Assembly position is that those orders are invalid. Those orders cannot be validated in the manner that is provided for by the judiciary. They cannot be validated from the judiciary CTS portal. Once you interrogate them against the practice directions of the High Court and all courts that we have already supplied a copy of, then you'll find that there is no means to verify as a house whether those orders indeed issued from the court. And that will find the particulars at paragraph 13. Interestingly, and we have next a copy of the said orders, you will see as a next in our affidavit, you'll see, for example, the first order that purportedly issued on the 2nd of October when the motion was being debated before the House. The parties to that order were the County Assembly and the Speaker of the County Assembly. But it appears that the orders mutated a day after without any reference to the procedure allowed and known to all of us as provided for under Rule 18 of the Mutunga Rules as to how you can amend a petition and amend a motion before the House. So they mutated on the 3rd of October to thereafter bring the Senate and the Speaker of the Senate as parties to the order. How did they mutate? How was Senate and the Speaker brought to the same matter within a day without its participation? You will see that we have referred to the screenshots that made the County Assembly aware of these orders. These orders, the County Assembly has taken the position that it was not served with those orders, and that is paragraph 9 of the reply affidavit. That's an issue of fact that shall require strict proof. We have not been led to any affidavit of service by counsel as to indicate whether those orders were served. It is straight law that an order that has not been served is inoperative for all intents and purposes, including these proceedings. The orders appear to have been, and I'm referring to page 8 of this volume. If you look at the timestamp on top, they appear to have been circulated as early as 11:50 a.m. But when you go to the CTS portal of the judiciary, the application that yielded these orders was filed at 12:10. So we have a situation, honorable members, where an order issued before even the application was filed. That is for the Senate to consider, and we have escalated that matter as an issue of investigation before the JSC, Judicial Service Commission. We have annexed a letter, a very comprehensive letter, that I do not wish to reiterate its contents on before this House. Secondly, as I finish, without prejudice to those arguments, we have argued, and I want to make reference to paragraph 19 of the reply in affidavit. We have argued on the import of these orders. Are they applicable to the Senate to the intent of stopping the Senate from hearing these particular impeachment proceedings? We have referred to the decision by the Supreme Court in the Justice Kariuki Mate matter. This decision is annexed for the benefit of Senate. It's a decision that I had the pleasure of arguing in the Supreme Court together with Senator Professor Ojenda, who is seated here, where the Supreme Court was quite explicit that a court cannot restrain a constitutional organ that is operating within its time-bound constitutional limits. And that I refer to the holding of the Supreme Court at paragraph 11, which you'll find at page 20 of the volume. The import of that holding to this House is that the two orders referred to by counsel for the county governor cannot serve or cannot have the effect of stopping the proceedings before this House. And finally, as I sit down, this Senate has already taken a position in that matter. I will do nothing more than refer the Senate to page 59 Page 59, this will be the last document I refer to because of time. Yes, I'm actually yielding the floor to my colleague. Page 59 is a position taken by the Senate in these proceedings, in this matter. And the Senate has said, by way of a preliminary objection, that we are not bound by that order. It has told the High Court in no uncertain terms that we are not bound by that order to the extent that it does not comply with the settled jurisprudence by the Supreme Court, which has been followed with approval by the Court of Appeal in the Mwangaza case and in many other cases, including decisions of the Senate, specifically in the Sonko matter and also in the Wambora 2 matter, which decisions are within the House. I yield the floor to my colleague to urge the issue of the threshold, the number threshold. Thank you.
Mr. Speaker, sir, honorable members, for the record, my name is Hilary Kiplangat. I will address the third preliminary objection, which is the question of whether the threshold of 2/3 required by Section 33 of the County Governments Act was met in the impeachment of Governor Honorable ERICK MUTAI. Mr. Speaker, sir, honorable members, Section 33 of the County Governments Act indeed requires the County Assembly to satisfy a threshold of 2/3 of its members to pass a motion for the impeachment of the governor. The controversy in this case, Honorable Speaker, is that 31 members voted in support of the motion, and in the humble submissions of the Speaker as per the Hansard of that day, that constituted 2/3 of the members of the County Assembly. Mr. Speaker, sir, in his ruling, the Speaker of the County Assembly, in page 131 of volume 1 of our documents, allowed himself to be guided by a decision of the High Court, and that is the case of Michael Justin Ngaduda versus the County Assembly of Tana River and 4 others. KELRC 1605, in which a judge of the High Court by the name Justice Manani had held that when it comes to matters rounding off, one rounds off to the nearest whole number. So, Mr. Speaker, sir, when it came to that determination, the Speaker of the County Assembly was guided by a constitutional position which had been determined by the High Court in that particular case which I have cited. Mr. Speaker, sir, that position that is volume 1 of our documents, page 131, you will find the ruling of the Speaker in which he cited the case of Justin Ngaduda versus the County Assembly of Tana River. Mr. Speaker, sir, the decision of Justice Manani is an application of elementary mathematical rule of rounding off, in which numbers are ordinarily rounded off to the nearest whole number. The same formula, Mr. Speaker, sir, has been applied in various other decisions of courts, and a case in point is the case of Adrian Kamodho Njenga versus Judicial Service Commission, which interrogated the composition of the Supreme Court in compliance with the requirements that no more than 2/3 of the same gender shall be in that appointive position. And in that case, Honorable Speaker, the High Court and the Court of Appeal were very clear that when it comes to rounding off, you round off to the nearest whole number. So the reigning jurisprudence which has been handed down by our courts is that one rounds off to the nearest whole number. In this particular case, honorable members and Mr. Speaker, sir, there are 47 members of the County Assembly of Kericho. To achieve 2/3 of 47, it will give you a number of 31.33. The nearest whole number to 31.33 is 31, not 32. That is in keeping with the jurisprudence which has been settled by our courts. Suffice to note, honorable members and Mr. Speaker, sir, in County Assembly of Kericho, there are 30 electoral wards. Out of the 30 electoral wards, 29 men were elected as MCAs, and 1 woman was elected as a member of the County Assembly. IEBC, in constituting the gender quotas for purposes of nominations, nominated an additional 2 men, making the number to be 31 men against 15 nominated women. Thus, the number of nominated women in the County Assembly is 16. So, 31 men in the wisdom of IEBC, and it is important to note that IEBC is a constitutionally mandated body that can ascertain gender quotas as per the law, and in their wisdom, 2/3 is 31. And that is why at the County Assembly of Kericho today, we have 31 men and 16 women MCAs. Even if we were to convert these figures, Honorable Speaker, to percentages, you will realize that if we were to argue that 32 was 2/3, it would yield a percentage of 68.05%. And in actual sense, 2/3 would be a percentage of 66.67. So you will see that variance even if you convert those figures into percentages. And in any event, honorable members, Mr. Speaker, sir, if one was to argue logically that 2/3 is 32 and 1/3 is 16, we would be having a figure of 48 MCAs in the County Assembly of Kericho, which is not in actual sense the position, because we have 47 members of the County Assembly. So, honorable members, this is a constitutional question which has been settled by the courts in Kenya, and keeping with the doctrine of stare decisis, which provides that bodies adjudicating on disputes which touches on the Constitution or the law are bound by the decision of the High Court or Superior Court. The decision in the case of Ngaduda versus the County Assembly of Tana River, as well as Adrian Jenga Kamodo versus Judicial Service Commission, is binding in this House. It doesn't matter how many times the county assemblies or parliament has applied a different formula. The only time when this matter has come up for determination is before the High Court, and the High Court has given a finding that you round off to the nearest whole number when you are confronted with an issue which requires numbers to be rounded off. Mr. Speaker, sir, those are our submissions in respect of the third preliminary objection, unless my learned senior, Mr. Bosek, has to add, which you can give him a minute or so.
Clerk, how much time do? is still available to the County Assembly.
Yes, sir. Just to add a few more points, Mr. Speaker, sir. The answer that we've been supplied by learned friend Katwa Keegan have not been certified and also are not complete. I wish to also point out that when you look at what is purported to be the answered, there is a disclaimer that this electronic version of the official answered report is for information purposes only. A certified version of the report can be obtained from the answered editor. Mr. Speaker, sir, honorable senators, we have not been furnished with any document that shows that the same had been certified by the answered senator. In fact, we are not seeing any input from the answered senator. Having said that, we therefore stand to say that whatever that has been produced purported to be from the KERICHO County Assembly, just like the documents which were purported to have been produced from the High Court in form of orders, did not go through the process of certification, and therefore they are of no probative value. And on that basis, we urge the honorable senators to look at them and to also question why council will produce documents which are in themselves self-defeating. I say no more. Thank you, Mr. Speaker, sir, honorable senators.
Thank you. Before I allow senators to make the intervention, Counsel for Governor, you may make your rejoinder.
Thank you very much, Mr. Speaker, sir. The first and the point I really just want to emphasize that for the honorable governor, we place a lot of premium on the contention that the 2/3 was not met. And as a starting point in response to what my colleagues have said, Mr. Speaker, sir, it can be taken as an absolute fact that it was actually 31 people who voted, and that that what was required was 31.3. So that it then leaves the question, as we already posed, as to whether when you scale down to 31, and as my learned friend Mr. Hillary has said, you round off to the nearest number, whether you would still be meeting the requirements of Section 33, being at least to that. The second argument I wish to make in response to the arguments is the question of whether this is a question of fact. Mr. Speaker, sir, and honorable senators, they said it is a question of fact. They will call a witness to say this and this, but we are all in agreement on what the bottom lines are. It is governed by Section 33 of County Governments Act. It's governed by Section 74 of KERICHO County Government Standing Orders. The county assembly members is 47. Those who voted at 31, the requirements is 31.3. Those are absolute facts which are not in contention, and no witness can change them one way or the other. So then, Mr. Speaker, sir, and honorable senators, the issue is ripe for your determination. It is ripe for your determination as to whether you can scale down 31.3 to 31. My colleague has also said that, Mr. Boseka said that the handsets we have relied on have not been certified. We wish to point out, Mr. Speaker, sir, that the handsets on their face say the handsets are for information purposes. And Mr. Speaker, sir, we are happy enough to rely on them to the extent to which they represent information, Mr. Speaker, sir. It is of significance also that they do not deny that those are accurate representation of what happened in the county assembly during the impeachment of the predecessor of ERICK, that is Honorable Chepcoin, and they do not contest that that was the criteria used to elect the speaker. Mr. Speaker, sir, then there is the contest about the question of the orders. Mr. Speaker, sir, we take this Senate very seriously. and we cannot possibly have come with forged orders. And we are really, really astounded that advocates of the magnitude and the standing of the county assembly could possibly say that the orders are a forgery. Now, the specific allegation that the orders were not served, Mr. Speaker, sir, volume 2 at page 487 shows that the orders were indeed served, and there's an affidavit of service. You will also see from the Hansard brought by the county assembly that, first of all, the affidavit of service shows the service was effected between 9:10 and 10 o'clock. The voting for purposes of the impeachment was done at 2, as can be seen in the answer that was produced by the county assembly at page 58. If you go at page 160, at page 161, it shows that they completed their process of impeachment at 2:18. So clearly, service was effected long before they did the voting. Mr. Speaker, sir, we stand with the orders. It is also significant that they say there was a forgery, but my very good friend, Mr. Hillary, filed a notice of appointment to come into that case the day after, on the 3rd of October. If they are saying there were no orders, what were they doing getting into that case and participating in that case saying we want to represent the county assembly and challenge the orders obtained? And Mr. Speaker, sir, we take exception at the allegations made about the orders not being proper. Mr. Speaker, sir, with that, I would like to rest my response and request for your indulgence for just 1 minute for my learned friend, Mr. Tonento, just to say one thing, and we rest our case. Kindly, Mr. Speaker, sir.
Honorable Speaker, members of the House, for the record purposes, my name is Tunen Manasseh, and I rise only to respond to one issue, Mr. Speaker, and that is the issue of 2/3, as indicated by my learned colleague, Mr. Hillary. Honorable Speaker, the issue of 2/3 is not a mathematical question in this instance. It is indeed a legal question. And if you take, for instance, Mr. Speaker, that at 31.3, a line of a threshold has been drawn. And the law states, and in mandatory terms, that it should be at least 31.3. That means that you have to scale up the numbers to meet that threshold. Because if you reduce the numbers to 31.1 or 31, that means that you've fallen below the threshold that is provided by law. Mr. Speaker, as you are aware, even in the standing orders of this House, standing order 7 in the election of the Speaker, Mr. Speaker, the House is composed of 67 senators, and 2/3 of that is a decimal point. Mr. Speaker, and as you can recall, on your election, the numbers were scaled up and not scaled down. This means that you do not reduce the number below what the law provides. So, Mr. Speaker, as you rule or as the House debates on that, consider that a 0.3 of a person needs to be completed. You do not negate or remove that particular person. So in our submission, we hold the position that the threshold was not met. Mr. Speaker, and also one issue that Hillary raised, and it was containing the issue of the gender in the County Assembly of Kericho. Honorable Speaker, the issue of gender in the County of Kericho is not the same and is not captured under Section 33 of the County Governments Act. Mr. Speaker, we urge the House to look at what the law provides and if we can scale down to that. And this House, Mr. Speaker, let it not be the House that sets the record or give precedence that you can play with numbers. Let the House be very firm in its decision and uphold the rule of law. That will be all, Honorable Speaker.
Thank you, Council for the County Assembly and Council for the Governor. Now, I will allow honorable senators to make intervention in this regard. Now, honorable senators, you will notice that this is not the ordinary preliminary objection that we've been dealt with before. It's a preliminary objection that is of a fundamental nature. It may or may not terminate these proceedings. And therefore, as you make your intervention, have that in mind. I will start with Senator Edwin Sifuna.
Honorable Speaker, allow me to put the question to Council for the...
Yeah, Senator for Meru. Certainly you cannot stand on a point of order because I don't see anything disorderly from the Senator for Nairobi. Just take a seat, Senator Sifuna, unless you're seeking for any intervention.
Honorable Speaker, of course, the honorable member for Nairobi, Senator for Nairobi, is quite in order. But I was just seeking one guidance, Mr. Speaker. Also looking at the time, maybe you can guidance on the number of minutes we can take on this, the senators, and also how many minutes can one senator use on the floor, Mr. Speaker.
Honorable senators, if you strictly apply the rules of procedure, then you have 2 minutes. Proceed. And 2 minutes it is.
Thank you, Honorable Speaker. My question goes to Council for the Governor. And Honorable Speaker, I would like to refer him to volume 1 of his documents. At page 7, Honorable Speaker, paragraph 20. There is an averment there, Council, that has been made by the Governor that in fact there was a holding of the High Court, and this is in reference to Malindi ELRC petition number E006. I don't know if we are together. Council, page 7 of the bundle at paragraph 20. Council, the volume number 1 of the Governor's bundle, page 7, for heaven's sake, Honorable Speaker, my time is being wasted by things that I've already said.
Just proceed.
Honorable Speaker, I'm referring to bundle, volume 1 of the Governor's
Senator
bundle.
Sifuna, you
at page
can only
7.
repeat if I tell you to repeat.
Thank you, Honorable Speaker. Council, you have presented the averments at paragraph 20A as a holding of the court, that in fact the paragraphs you have superimposed there were a holding of the court. Now, you are a lawyer of great repute, and reading a judgment you can ascertain what a finding of the court is as opposed to an analysis of the presentations of the parties. Honorable Speaker, the judgment referred to is at page 70 of that same bundle, exhibit number 1. And I want the Council for the Governor to confirm to this House that in fact, the paragraph quoted at 20A is not a finding of the court on the question of what 2/3 means and what should happen when there is a decimal. Honorable Speaker, I will refer you to paragraphs. He has quoted from paragraph 83, which cannot be a holding of the court. And in fact, the holding of the court should be at paragraph 86 of that judgment. Honorable Speaker, my question therefore to him is it proper for you to present an analysis of the case by the learned judge as a finding of the court? Honorable Speaker, that is the question I wanted to put to him.
Senator Boni.
Thank you, Mr. Speaker. Mr. Speaker, my comment on this will be limited on what I beg that the House adopts to help this country. This is a very serious matter, and Mr. Speaker, it is already on record that no court can injunct Parliament. So the first PO should collapse. A decision has already been made. My second comment, Mr. Speaker, is on the question of numbers. Kanzo Mutuma, what would you like the governor to prove? It is a scientific fact that 47 divided by 2/3 is 31.3. As you guys say in law, res ipsa loquitur. It proves by itself. What do you want him to prove? It is not possible for a human being, Mr. Speaker, to be a fraction. I want, Mr. Speaker, to urge the council that because you also have a responsibility to grow the philosophy of impeachments, let us agree that on this one, let us give it to the governor. We give him the fact that a fraction of a human being does not exist. Next time, come with full numbers and we would listen to you. Finally, Mutuma, because you're very experienced in this process, listen to what the Speaker of the National Assembly said about the same thing. The County Assembly of Nyamira said about the same thing. The County Assembly of KERICHO about numbers during elections. They have said the same thing. So why do you invite us to disagree with all of them? So as to please you or to allow the proper jurisprudence?
Senator Ledama.
Thank you, Mr. Speaker. Mr. Speaker, I just want some clarity from the Council of the Governor. The Council for the Assembly has presented facts that this matter had already been determined by a court. In their Volume 1, page 131, there's a finding of the court that when it comes to the issue of 2/3, it is not an issue where you determine the question of a human being being able to be fractioned, but rather a scientific. Are you then, in your submission, questioning, or rather, have you challenged, or has anyone else challenged that finding of the court in the matter of Michael Justin Dunda with the County Assembly of Tana River? So that is a point that I'd like you to clarify, because this is a finding of the court. Number two on that issue is on the finding on the matter to deal with JSC, where the court, according to the facts presented by the Assembly, stated that you round off to the nearest whole number. What would be the nearest whole number in a matter which is 31.3? Is it 31 or is it 32? Thank you, Mr. Speaker.
Senator Fernandez, Senator Samson Chirange.
Mr. Speaker, you need to protect me from the majority leader. Mr. Speaker, I want to agree with my colleagues. Just a quick comment is that in the history of this parliament, no one can injunct parliament. So I think on that aspect of injunction of parliament or court order before the parliament or the Senate, it does not hold water, and therefore I think I would advise the defense team of the governor to stop pursuing that line. Number two, and finally, Mr. Speaker, on the issue of 2/3, Mr. Speaker, my concern is on Section 33 of the County Governments Act and Article 181 on removal of governor. Mr. Speaker, and in the decision of Raila Odinga versus IEBC in 2013, the Supreme Court pronounced itself that when the process, and I want to extrapolate, when the process has taken off and it is time-bound, as envisaged in that ruling before the Supreme Court, that process is time-bound. So by the fact that you read the charges and the process is ongoing, when you look at rule number 16, rule number 14, and rule number 30 on the removal of a governor, the process is already ongoing and the train has left the station. So, Mr. Speaker, the question should be, if the process has already begun, as per Section 33, with the genesis of Article 181 on removal of the governor. Therefore, what happens, Mr. Speaker? I agree that in scientific proof that you cannot have a fraction of a human being. But also, for some of us who are not very good in mathematics, there is also principle of truncation. So, Mr. Speaker, you must balance both so that at the end of the day, we give justice to the county assembly and we give justice to the governor and any other person, including the people of Kericho, Mr. Speaker. So since the train has left the station, let us go ahead and listen to the merits and demerits of the case, and then we determine. I submit, Mr. Speaker.
Senator Kajwang.
Mr. Speaker, the issue of limits of judicial authority on independent institutions has been settled. And I think we have seen some precedents that have been presented to us. Secondly, we need to make a distinction between procedural fairness and procedural technicality. Procedural fairness demands that the governor for Kericho has been accused of gross misconduct, and all sorts of allegations have been made against him. This is his opportunity to defend himself against those allegations. There should be procedural fairness as required in our Constitution. The other aspect is procedural technicality. And Mr. Speaker, you do recall that if we were to be obsessed with procedural technicality, in 1992 it is John Harun Mwau who would have been the president of Kenya, because he went to court and said he's the only one who presented his petition in a foolscap rather than on an A4 paper. Mr. Speaker, the ruling that has been referred to by both parties, we are getting different interpretation. On this matter, we should not go with Rule 30. Rule 30 empowers the Speaker to make a decision. Mr. Speaker, I want to encourage, the way we did in the case of Nairobi Governor Sonko, there were affidavits that were sworn by MCAs that discredited the outcome of the vote. The Speaker ruled that let's allow all parties to prosecute their case, and then the senators sitting as a jury would make a decision on the ultimate day of voting. I would propose and I would urge, Mr. Speaker, that we do not refer to Rule number 30, but allow the House to proceed and ensure that there is procedural fairness in the matter of Kericho.
Senator Kathuri.
Thank you, Honorable Speaker, for this chance of the 2 minutes also to make a comment on this very, very important matter. And Mr. Speaker, as we are here, many Kenyans are watching at us. They are grown on their TVs because, you know, many Kenyans are now sensitive on devolution, sensitive on governance, and all these things. So, Mr. Speaker, the PO number 1 is actually dispensed of naturally. So the PO number 2, Mr. Speaker, besides, because that 1.3, the High Court pronounced itself that you go to the nearest whole number. When you go to the nearest whole number, you run at that one, Mr. Speaker. The other argument is about now the direction that has been put in Kericho County when they were electing the Speaker of the County Assembly. So, Mr. Speaker, because this matter is about mathematics, so what I would request, as also other colleagues are putting it, Mr. Speaker, we would like to hear these cases. We give the Kericho County Assembly and the Kericho County Governor time to prosecute their matter before this Senate, Mr. Speaker. Because if we determine this matter in any other way, rather than listening to the parties, then we will not be giving justice to the good people of Kericho and the country at large, Mr. Speaker. So Senate will be a house that cannot be able to protect the devolution, Mr. Speaker. So in my submission, I wish that we are able to listen to both sides, and then we are judges. This is a High Court sitting, Mr. Speaker. We will be able to make our determination in one or the other, Mr. Speaker. Thank you very much.
Senator Wambua.
I thank you, Mr. Speaker. Mr. Speaker, two things. One, I don't know why my colleague, my friend, Senator Alwale would want to pick and choose on court rulings. A precedent has been set in the court, and he has quoted it, on the matter of separation of powers, that no court can injunct a parliament in its deliberative roles. And so PO number 1, everybody agrees, it falls on its face. Speaker, then PO number 2. You know, what the lawyers on both sides are asking these judges here to do is a very complicated matter. It's a matter of determining a fraction of a human being. What is 0.3 of a human being? Is it the head? Is it what is it? But the Speaker, again, the courts have pronounced themselves on that matter. And in the case of Tana River, they have said that in a matter like this, then you round off to the nearest whole number, which is 31. Mr. Speaker, there are substantive matters for determination in this motion that this House needs to be engaged in. And you ask me, Mr. Speaker, as Senator Cherargei has said, the train has already left the station. We are already in motion. Let us hear this case. Let's make a determination one way or the other. Mr. Speaker, I submit.
Senator Aaron Cheriot.
Thank you, Mr. Speaker. Mr. Speaker, the people of Kericho have quarreled, and we've come before this House to seek for justice. And we pray for nothing less than justice in the interest of the people of Kericho. I want to make 2 quick observations, Mr. Speaker. One is unanimous by what colleagues have said, that PO number 1 has been determined by not only by Parliament itself, by none other than the Supreme Court of the Republic of Kenya in Wambora 1, 2015, Mr. Speaker, where it has been firmly established on what you do with a parliamentary process, either in Parliament or at the County Assembly, once an exercise has commenced. Therefore, on that count, Mr. Speaker, I plead that the Council for Governor notices and appreciates that particular issue. Second and most important, Mr. Speaker, is on this issue, and I wish my good friend Senator Boni Halwale listens keenly to this. Mr. Speaker, there is what you call the hierarchy of law, where the Constitution reigns supreme, it sits at the top. And when a matter is not sufficiently addressed in the Constitution, you look for it in statute or legislation that we have passed here. Where there is none, Mr. Speaker, what follows a third after that is already established case law. Mr. Speaker, the Speaker of the County Assembly of Kericho, in his affidavit, and it is hereby presented in volume 8 of the documents from the Assembly, cited court decisions that have been made on this particular issue. Therefore, Mr. Speaker, I don't know on what basis you would want to fault the Assembly, because I have listened to Council for Governor and there is no citation whatsoever on their part other than application of mathematics and this theory that we want to be told that there is no half or quarter of a human being. I thought, Mr. Speaker, that being a house of procedure, we would establish what is a practice that has been established in our courts of law. Mr. Speaker, you know, what I find to be extremely curious, though, is a very dangerous invitation that the Council for Governor is sending out to you. I listened to him, Mr. Speaker, and he wants to lead you to make a decision that has never been made by any other speaker in this House, Mr. Speaker, where he wants you to make a determination on appeal and dismiss this case altogether.
Now, have a seat. Now, honorable senators, it is now 4 minutes past 1. We can only, during a morning session, prosecute business up to 1 p.m. And therefore, allow me to invoke Standing Order 34, 2A, to extend the time for 15 minutes. Thereafter, we shall rise for a break. We'll come back at 2:30 and prosecute this matter because it is of such a fundamental nature. I'll give you 1 minute to conclude.
Mr. Speaker, you are being invited to very dangerous path. Previously, before this House, in Mike Sonko versus County Assembly of Nairobi, and